the ordinary understanding is that someone leaving a will is an older person, someone who has a lot of assets, someone with plenty money, someone with plenty to lose, someone who is near death. There are all sorts of different opinions in relation to why a will is needed, who should have a will, and the authority of the document. And we were hoping this evening to get into that discussion because in my humble opinion, every single living human being and citizen of Trinidad and Tobago over the age of 18 years should do the responsible thing and have a will done. Now, guys, let me know if you are hearing me, if my video is frozen or if my audio is giving you any difficulty, because I don't want to start this information and you guys are not with me. So please indicate to me if you are hearing me. Yeah? And if you are seeing me, if you are hearing me and if you are seeing me. Because we have well over, we have a lot of persons who are in. Good. Everybody said good to go now. Excellent. You're hearing me. Nice. So we're touching on the topic of wills and why we need it. Now, a will, let's first start with the definition of will. Legally, a will is, in simple terms, a formal document. I don't like to call a will a legal document because it is not legal until it gets the power to so constitute. And I will explain what I mean by that. So I will define a will as a formal document that outlines and dictates in your life how you wish your assets and legal authority to be distributed after you die. And I'll repeat the definition. A will, and this is my definition. If you Google, you may have a different opinion. But in terms of, in my experience doing wills and probate over the years, I think the best way to describe a will be to state that it is a formal document, a written formal document that dictates how you want your assets and your legal authority to be distributed and administered after you die. And there's a reason why I would have used certain words like those in my definition is because this evening I am hoping that those aspects or features of a will is truly understood by each and every participant and attendee at this evening's webinar. Now, the usual understanding of a will is that, is this document for me to give away my things to my children? And if I don't have anything, then there's no reason to write one. Now, if you would go back to how I defined a will, you would know that I would have included that a will is written. But not only that, it dictates how you want your assets to be distributed and your legal authority after you die. And that is the aspect this evening I am hoping to shed greater light on or to focus. Because oftentimes persons focus on the gifting ability of a will. Yes, a will is primarily used to gift your assets or your belongings to whosoever you have outlined and expressed to be the beneficiary therein. However, a very important feature of a will, primarily the executor or executrix feature there of a will, actually dictates who you are appointing to represent your legal interests or be your voice or your authority beyond death. A will is the only legal document or the only formal document that once made legal can give any other living person that authority. It is the only document that speaks from the grave. And this is something that Tummy would have heard from my very own colleague, and she would have taught me in school, Miss Avian Joseph, being a probate expert herself. She often describes a will as that, a document that speaks from the grave. Because in law, all other documents that you may have done, for instance, a power of attorney, where many of you may be quite familiar, that document usually dies, or not usually, it definitely dies when you die. That power dies when you die. all other things. If you were in the middle of a transaction and you didn't yet finish, if you die, that dies as well. Your obligation dies with other things. Everything is said to be have fallen in your estate, including any entitlement that you would have died with. And so that is what I want to really highlight, because I see persons often make the mistake and say, well, I am so young, I haven't acquired that much of, assets, I don't have anything to leave. You never know the manner in which you are going to die. And I will repeat that. You never know the manner in which you are going to die. And it is a very dear point to me, because I would have firsthand lived that experience, having close relatives die very suddenly and brutally, right? And their will helping in establishing who would have spoken for them after death, who would have represented their interests in court, who would have taken the matter to court and benefit or demand redress. Let me give you a very real example and case study. Many persons don't think about, well, what if I die in a manner that entitles me for compensation? Who is going to be responsible for overseeing that my family and my estate gets what is owed to me? If you get involved in a vehicular accident, or it is a freak accident, something happens to you and you slip and fell, you hit your head, because that is how death happens, people. I'm not sure if you all recognize that, death doesn't only happen after old age. We are all mortal. And I do understand that when persons talk about wills, they are faced with their mortality, perhaps before that, they want to. But our mortality as living people is a very real part of life. Death is a realistic part of life. Any of us can die at any given moment. And we do not go around thinking of death, but the truth is, it can fall upon us at any given time. And having a written will is a responsible provision that prevents unnecessary, and I will say that again, having a will is a responsible provision, and may I say a loving provision that prevents unnecessary unsurety and lack of clarity as it relates to what is to be done with you after you have died, or after you may have died. And we're talking about how you are to be, how is your body to be disposed of, whether you prefer to be cremated or buried. All of these things can be included in a will. If you are currently the owner of properties, who is to get that and who is to administer it? If you are the director of a company, or you hold a very responsible position, or you are a shareholder in a friend's company and you are entitled to things, all sorts of things. If you have a loan, if you are volunteer somewhere, if you own a patent that everybody is relying on, or if you would have discovered some, so many things we do while we are alive that we don't protect for death. And it is a really important conversation to have. What I want to go into today, because I know Mr. Paul is not able to join me, but we would have discussed before and agreed to really tackle this topic from the slant of case studies. We want to talk about some of the real cases that we have seen and real instances where, if the deceased had made a will and did not die intestate, because that is the term used for someone who died without leaving their last will. Had they not died intestate, much of this would have been avoided.